Hello and welcome to the Ken Vercammen Law Office Legal Podcast. We're looking here at an unreported case where the appellate division held suppression should be granted where the parked car did not qualify as an investigative detention. The defendant had appealed the denial of his motion to suppress evidence in his DWI conviction. The officer on patrol in a park noticed a car in the parking lot that was usually empty at that time of day. The officer saw the car engine was running and approached the vehicle. The defendant driver was on his cell phone. The officer waited for him to finish his call. The officer observed the defendant's eyes were bloodshot and watery. There was a strong odor of alcohol coming from the car and alcoholic beverages in the car. The officer talked to the defendant and issued the summons. The defendant moved to suppress the arrest, and the municipal court judge found that there was a valid field inquiry. It required no justification. The defendant conditionally pled guilty. The law division heard the case de novo, and again found that it was a field inquiry. The court then found that he was being guilty. So the next step is to appeal to the appellate division. On appeal, the defendant argued the interaction was an investigative detention because the officer parked his car behind the defendant's car and no reasonable person would have been felt free to leave. The appellate court agreed and reversed. The officer's mere approach to a parked car did not automatically qualify as an investigative detention, but when the officer parked his car to block the defendant into the parking space, interaction became investigatory detention and was not community caretaking. And the name of this case is State versus Duffy. It's unreported, but it's helpful to people charged with DWI. Document number A-0641-21. For more information on DWI defenses, visit website njlaws.com or benotguilty.com. That's benotguilty.com. And for representation, contact Ken Vercammen's office in Edison, 732-572-0500. Thank you.